All right, good morning, everyone.
Good morning, Judge Richardson.
Good morning to our reconvened hearing. I think we have ironed out our administrative difficulties and we're finally ready to go forward on what should be two remaining motions. I had Amber Kane versus Wilkerson and Royal Trucking Company. I believe that case is settled. We don't have anyone here on that one, do we? All right, hearing none. Do we have folks here for Patrick versus NG Mejoy joint venture et al?
Good morning, Your Honor.
Ms. Foster.
Yes, good morning, Your Honor. Here on behalf of NG Mejoy.
All right.
Again, good morning, Your Honor. Aaron Michaelman here on behalf of the plaintiff, Veronica Patrick.
All right. So let's go ahead. With the motion, Ms. Foster.
Yes, Your Honor.
Right. All right.
I apologize. My computer froze, of course, as soon as you called us. I thought we were stacking up, so I thought I still had one more minute. I had to reboot it. So give me 1 second, Your Honor. I apologize.
All right. Well, while your computer is rebooting, you know you may have an uphill battle here with me today because I've already entered.
I understand, Your
summary
Honor.
Judgment on.
I understand,
Wilkerson. All right.
but I'm still here. And
I'm here. I'm ready to listen. I'm ready for you to change my mind and point out something that I'm just completely missing.
thank you for your patience, Your Honor. Again, my name is Jennifer Foster. I am counsel for Defendant BE Global, Inc. Your Honor, Defendant BE Global, and I'm going to refer to as just Defendant BE for the sake of this motions hearing, filed its motion for summary judgment on March 16, 2021. Defendant asserts that there is an absence of evidence supporting essential elements to plaintiff's case, specifically plaintiff's claims against BE specifically. A bit of procedural history, Your Honor. The subject matter was a refiled suit refiled on April 3rd, 2020. Plaintiff originally filed their suit on March 21st, 2017. In regards to the procedural history, initially when they filed suit, they simply filed suit against NG Mejoy joint venture, which I'll refer to as joint venture moving forward, Your Honor. Joint venture then filed a third-party complaint against BE, bringing them into the original suit. And then in the refiled suit, plaintiff filed suit directly against both joint venture as well as BE. Defendant BE, we approached this motion for summary judgment, Your Honor, on two separate fronts. On the first front, which is that plaintiff has failed to demonstrate that defendant BE is directly or vicariously liable to plaintiff in this specific case. And then on the second front, which to some degree this court has already addressed in their previous order with our co-defendant joint venture, we still assert, Your Honor, that defendant is entitled to summary judgment because plaintiff has not proven that defendant had actual or constructive knowledge of any hazard in this specific instance. On January 16, 2016, while at the rental car center at Atlanta Hartsfield-Jackson Airport, plaintiff allegedly fell in the women's restroom. During her deposition, she testified that she did not know where the substance or the water came from. She didn't know how long the substance had been on the particular floor. She wasn't able to provide any details in regards to the quantity or how much water or the substance was on the floor that caused the alleged fall, Your Honor. Plaintiff erroneously alleges that defendant BE contracted with the city of Atlanta, when in fact it was the city of Atlanta who had a contract with Joint Venture, our co-defendant, to handle the operations of the premises, which are at the center of this particular suit and for this motion, Your Honor. Joint Venture then did a subcontract with my client's BE. And in those particular understandings of that contract relationship, BE was simply supposed to provide personnel to Joint Venture, Your Honor. We assert that plaintiff has failed to demonstrate that the defendant contractually owed a duty to the plaintiff. Plaintiff must prove that BE maintained control of the manner in which the custodial staff performed their duties. However, Your Honor, all the evidence shows to the contrary. All the evidence shows that BE provided staffing personnel to the co-defendant Joint Venture.
Doesn't the actual language of the contract count?
Well, Your Honor,
The contract seems to suggest that BE Global is to use its independent judgment and performing, the manner of performance as opposed to the goals of the performance, which are laid out. Isn't that some evidence that BE Global had some independent discretion as to how to carry out the duties there?
well, Your Honor, it's our contention that the evidence that has not been contradicted, in our opinion, Your Honor, are the affidavits from Joint Ventures, CEO Michelle Hidston, and then the affidavits.
Right, there's affidavits, but if there's a contractual language that's evidencing the party's intention.
Well, Your Honor, we would state that the court needs to turn to the practices of the parties regarding how they actually perform the duties between the two of them, Your Honor. And we would also assert that the contract that was essentially, that the contract between JB as well as BE is boilerplate in nature. It doesn't go into any real specificity into regards to what BE was actually supposed to do. The practices, we would argue, is what dictates the actual relationship and the understanding between the two. And then we would state that that's further substantiated by the affidavits, which are more recent than the actual contract from both of the representatives of the defendants. And by those affidavits, essentially all BE did was provide the personnel. It was JB who was in control of actually managing the staff. The individuals who were present at the time of plaintiff's alleged fall had on emblems that showed that they were employees of JB, Your Honor. And so we would state that in this particular instance, because we had no control of the premises, we had no control over the staff, we had no control in regards to managerial duties, we had no control into regards to the scheduling for when they're supposed to clean the premises, records and so forth. All of that was under the control of the co-defendant JB, Your Honor. And it's for these particular reasons that we would state that we had no duty to the plaintiff in this case, Your Honor. And again, I'm not going to belabor the point. The second front of our motion is similar to that which was filed by our co-defendants, which was that there was no actual constructive knowledge. But we would say, again, the distinguishing factor here is that we were a subcontractor that had absolutely no control over the premises. So we had no control over making sure that there was necessary procedures set up to ensure that there could have been constructive knowledge on behalf of one of the defendants. And again, Your Honor, it's for these reasons that we would request that BE's motion for summary judgment be granted.
All right. Thank you, Ms. Foster. Michaelman?
Thank you, Your Honor. I think I'll defer to counsel, to counsel for BE Global to discuss the intents of the parties amongst the contract. I'm not privy to that information, but I would suggest to the court that just like you can't put into a contract things that are against the law, you also can't use the law or aspects of the law or appellate holdings to ignore or avoid your obligations or responsibilities in a legal and otherwise binding contract. And I think, with all due respect to as Foster, that's what BE Global is attempting to do here. Position of a plaintiff would be that from the get-go on this case, there are many different entities that work within the airport. This was a matter that went into litigation in part because the airport's difficulty in tracking down the correct entities that were involved in it, some of which were revealed after the initial litigation was filed in this matter. But our position is essentially just that the contract speaks for itself, Judge, especially the sections that we pointed to in our response to the summary judgment motion, as the sections that relate to section 3.2 as it relates to the subcontractor's responsibility for implementing methods, procedures, and standards. Section 5.1, it outlines the standard of care that subcontractors are expected to perform for their job. Section 6 outlines the time that the job must be performed, and Section 10 outlines the indemnity obligation. So we also have a case in our reply, Kelly versus Piggly Wiggly Southern, that does actually have a holding that's different than that Fagans versus Kroger case that BE Global's brief relies on, that basically says that janitorial service contractors whose actions cause an injury to a third party can be held liable for those incidents. So for those reasons, Judge, we think the contract speaks for itself. And again, I'll defer to counsel for NG Mejoy to talk more. I'm sure they'll have some different or more detailed information for the court about how these contracts work between the parties. This is something that the airport does on a regular basis. So, but we appreciate the court's consideration in this case. Thank you.
So, Mr. Michael, let me ask you this question. So there's the affidavit from BE Global that says, all we're doing is handing personnel over to the joint venture. We don't have any control, regardless of what the contract says. Do you have any evidence other than the contractual language itself that suggests that BE Global had some independent discretion?
I don't, Judge, offhand, other than again, I think that the contract seems to make it pretty clear that there was more than just the intention of it being a handoff where the folks can come and they don't have any control over what they do or don't do. It pretty clearly states that it's their responsibility, even though they may not create the standards, it's their responsibility to make sure that they're carried out and that they're liable for it if they're not. So.
Right. And for the joint venture, I know this is not your motion, but do you have any say here or any interest in speaking
Well,
on either side?
I mean, I would echo that. I mean, the contract, I don't believe enough has been presented to allow the court on a summary judgment motion to ignore that plain reading of the contract, section 3.2 that Mr. Michaelman referenced. And I believe there's a recent June 2021 case on the borrowed servant doctrine, healthcare staffing versus Edwards, where in that case, where the, I don't remember the terminology, but the company that was in the same position as we are in, NG Mejoy, the joint venture, didn't have an exclusive right to terminate the employee, that it was found that the respondeat superior still applied to the staffing company. I mean, and that's just one of the three prongs that they looked at in that case. And there's nothing in the contract to suggest that we had any type of authority over these employees such as that. And I think that one could be a little bit instructive on a case like this. But ultimately, we would say that there's enough in that contract to at least get us past this point on the vicarious liability as they've argued in their summary judgment motion.
All right, thank you, Mr. Jones. Ms. Foster, you get the last word on this.
Yes, Your Honor. Well, I would say this case is not entirely analogous to the Piggly Wiggly case that is briefed or that is mentioned in plaintiff's briefs. In that specific instance, we would state that the janitorial services, that's joint venture, Your Honor, and that's not BE. I would just, again, state that we believe that the contract that has been attached to their motion is a boilerplate. It's a boilerplate contract, and that we think the court should turn to the practices of the parties. And the statement that we received, or the affidavit that's been produced by Joint Ventures Counsel, the affidavit of Michelle Hinston, in paragraph number 4 states that they had entered the contract with the city of Atlanta, and then Joint Venture subcontracted with BE Global to provide certain personnel, including custodial staff, Your Honor. And then in the same instance, in paragraph number 4 of Mr. Burt's affidavit, you have the same thing, that they only provided this custodial staff, that there was no managerial or no supervisory oversight. And so if they're not overseeing any of the details of the managing of the premises, how can they be liable for plaintiff's injuries?
All right, I think that, in the final analysis, when we get to trial, that, the actual practice out in the field is most likely going to carry the day. But, at summary judgment, there only has to be some evidence, even a sliver, that might authorize the jury to come out another way. And having a legally operative document that seems to create an intent contrary to how BE Global avers the duties were actually performed, I think it just creates a question of fact, because that contract, whether the parties filed it or not, is a legally operative document. And somebody at some point intended for it to be that way. So ultimately, the question is, did it occur that way in practice? There'll be opportunity for examination and cross-examination, but I think that has to happen at trial. So the motion for summary judgment is denied. We will issue an order.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, counsel.
May we be excused, Your Honor?
You all may be excused.
Thank you, Your Honor.
Good day.
All right, let's talk about Allen versus AATC et al. So we've got 2 separate motions for summary judgment. Mr. Stoddard, since you're having to defend on multiple fronts here, do you have a preference as to which one you want to defend first?
I have no preference, Your Honor. My view is they make nearly identical arguments. I'd almost rather them both just go, and then I can respond jointly to them.
All right, that's what we'll do. Let's start with the one that is first filed in time, I think, by 3 minutes. And that is HSS All N1 ATL LLC and HSS Inc.
Good morning, Your Honor. Charlie McDaniel here on behalf of these 2 entities. And I will, in large part, defer some of my argument to Brian Grantham, who represents the All-in-One security personnel. By way of background, the court knows that there's another defendant who has a motion for summary judgment pending, and that is AATC. And from a background standpoint, let me just give a thumbnail sketch of what we're dealing with. And ironically, it's another airport case that similar to one that you had just heard, with one grave distinction for purposes of these 2 motions for summary judgment that are pending. And that is that there was no, and I'll get into the reasons why, but I wanted the court to understand that the only basis by which we believe plaintiff can even argue that there is liability in the behalf of these 2 defendants is by virtue of whether or not there's evidence that any individual employee of either of the defendants actually created the hazard. And I will get into why there is no evidence to that effect. But from a background standpoint, AATC, and I'm not going to go into great detail, but they were under contract with the city of Atlanta and the airport to provide certain services at the Atlanta airport. And in this case, we're talking about Concourse C. Separate and distinct from the airport's contract with AATC, there was a contract between, and I'm just going to call it the HSS Inc. entity as opposed to HSS, and trying to keep the court mindful. HSS All-in-One ATL LLC. They are the entity that entered into a contract with the city of Atlanta. And HSS, previous to this contract, had contracted with the city of Atlanta to provide certain security services at the Atlanta airport. And those services are laid out in the contract, and those services essentially deal with security and airport screening responsibilities, and it's laid out in the contract. Prior to entering into the current contract, which has been filed in conjunction with our motion for summary judgment, the city of Atlanta requested that the parties who want to contract, similar to the case you just heard, do so under a joint venture. And previously, HSS had the contract with the city of Atlanta, and they contracted with a company like HSS All-in-One Security, who Mr. Grantham represents. In this case, they entered into a document and formed a company that's an LLC. That's HSS All-in-One ATL LLC. And that's the company that contracted with the city of Atlanta. There's an operating agreement between HSS ATL LLC, HSS Inc., and HSS All-in-One Security. And that document is also attached and filed with the court. And that lays out the circumstances and the obligations of these two entities, HSS and HSS All-in-One Security. The incident giving rise to this cause of action occurred when Mr. Allen came up an escalator and was proceeding to his flight on Concourse C, a Southwest Airlines flight Concourse C. And as he came up off the escalator, he walked along the concourse and took a sharp left, alleges that he tripped over a set of stacked mats, fell forward and fractured his femur, and ultimately has had significant surgery. The motion for summary judgment that HSS ATL LLC and HSS has filed has three basic premises or points to it. One is that the contract between HSS ATL LLC and the city of Atlanta does not create a third-party cause of action for Mr. Allen against any of these three entities. That's HSS ATL, HSS, or All-in-One Security. The contract is very clear, in fact, that there is specifically no right of a cause of action against any of these entities as a result of an incident that is incurred by a passenger.
Yeah, I'm with you on that point. So
All right, so
we can move to the more difficult points.
what I was going to say is that the city of Atlanta, I'm sorry, the plaintiff didn't really contest that issue. The second point is, therefore, since there's no contract, there's no duty under 5131. The only basis by which we believe plaintiff can even argue that any liability could be attributed to HSS or All-in-One Security is whether or not any of the employees of these two individual companies caused the hazard that led to Mr. Allen's fall. As to HSS, there is absolutely no evidence that HSS had any employee move the mats in question. And let me explain to you what the circumstances are. That the evidence has established that there is a there's a wall where a security personnel would stand. And in this particular case, on this concourse, that post was manned by an all-in-one security personnel. There, several years before this incident, there were discussions about having ergonomic mats and had 2 yellow footprints that were placed where the people would stand at post to relieve some of the stress on their feet. As you face that wall and off to the right, there's a little cove that leads to a doorway that leads to a back hallway. In that area, there were placed 2 mats that are similar to those that are used in restaurants and hotels for working where spills often occur. These mats, as I understand them, and the evidence showed, is that they were there in that location for people coming out of the hallway to wipe their feet on the mat and then move into the concourse area. The hallway was not an area that was utilized by passengers. It was purely security and airport personnel, but they would come in and out of that hallway. And the mats were supposed to be with the ergonomic mat right against the wall where the security officer would stand at post when he was there. And then off to the right were these 2 other rubber mats. On the morning of the fall, and the allegation is that the 2 rubber mats were stacked on top of the ergonomic mat, and that is what Mr. Allen alleges caused him to fall. As he walked along, Judge, he's alleged to have caught his foot under one of the 2 mats stacked on top of the ergonomic mat, and that caused him to trip and fall forward. The question is, who placed those 2 mats on top of the ergonomic mats? Plaintiff's entire argument as to both HSS and all-in-one security on that issue is premised on the fact that there is testimony that on occasions, all-in-one security personnel moved the mats and stacked them on the ergonomic mats. I'm going to let Mr. Grantham argue more about that issue because that deals with his security personnel. As to HSS, there is no testimony and no evidence in the record that anyone employed by HSS ever moved those ergonomic mats and stacked them anywhere. The evidence in the case is those rubber mats were moved on some occasions by a third contractor, RBM. And when I say third contractor, they were contracted with AATC to provide cleaning services. And the testimony from various witnesses is RBM would move those rubber mats out of the way so they could clean the floor. And there's testimony that on some occasions they would stack the mats, some occasions they would move the mats. There's also testimony that on some occasions, if the mats were stacked, the all-in-one security personnel would move the mats or not move the mats. The critical point that I wanted to highlight is, again, HSS, there's no testimony that anybody affiliated with HSS moved those mats, and particularly on the morning of this fall, put those mats on top of the ergonomic mat. Specifically as to all-in-one security, the specific testimony of the employees of all-in-one security on the morning of this occasion testified affirmatively that they did not stack the mats and the mats were not stacked when they were there. And again, I'm going to let Grantham go into a little bit more detail, but I wanted the court to understand that that's part of our position. Now, plaintiff cites a case, Kaplan versus Pulte Home Corporation. And he cites that case for the proposition that, and he cites it in his brief, that there's certain evidence that could lead the jury to believe the security companies created the hazard on the morning of the incident. And the could arises from bootstrapping various testimony that HSS personnel had originally obtained these mats, that all-in-one security personnel on occasion would move these mats and stack these mats and stand on the stacked mats. And he cites the Kaplan case for the proposition that if there's enough of an inference, then it goes to the jury. But I think that the court needs to really take into consideration the distinction between the Kaplan versus Pulte home case and what we have in this situation. In the Pulte case, you had a scenario where an individual slipped and fell in the December 28th, I believe, when there was an area where he was working had been washed down with a power washer, and then overnight black ice had formed, and he was unaware that black ice had formed. And Pulte moved for summary judgment. It was Pulte's contractor, America's Best, that was out there doing the work, but it was their property. And they moved for summary judgment because on the basis that there was no direct evidence that America's Best or anybody had actually power washed the area where he fell immediately before his fall. And the court denied, summary judgment with respect to that, and that the Court of Appeals upheld that and said that the work in the immediate area on that day, December 28th, and the prior 2 days on other houses created a reasonable inference that work was done or begun on the lot where Mr. Kaplan fell just prior to his fall, because the driveway was covered with a sheet of ice and there had been no rain or snow. So plaintiff wants to take that analysis, that case law, and that decision and bootstrap it into this case, but there are a couple of very clear distinctions. Number one, that America's Best could not give testimony of actual knowledge of when work was begun or finished on any of the 4 houses. She's only able to testify to what the record showed with respects to the invoices. And with respect to the invoices said that the washing on the lot where Mr. Kaplan fell was completed on December 29, 1995, which is the next day after he fell. The court said that, well, this gives a reasonable inference favorable to the plaintiff, that the washing began on the 28th, but was completed on the 29th. So despite the fact that the America's Best said, well, here's an invoice, they could not give direct testimony that they did not perform the work on the 28th. Another distinction is that there is no evidence of any other cause of water on that area where Mr. Kaplan fell other than America's Best power washing the area. So the distinction with our case is twofold, Judge. As to specific testimony regarding the cause of the alleged hazard, Mr. Grantham's client's witnesses had specifically testified, who were there that day, that they did not create it and they did not see the existence of the mats stacked on top of each other. And again, I'm gonna let Mr. Grantham speak more on that. So
Let me ask you this, Mr. McDaniel, because, we have a lot of cases where, we've seen a lot of cases, I know you've seen them too, where there's a circumstance where, there's a harm caused and 2 or 3 or 4 separate parties could be responsible for the harm. My experience is that you're never going to get one of those parties to say, I did it. And the plaintiff or the injured person is never going to be able to prove who did it because they weren't there. Doesn't it just make sense that we bring all the parties in the room that could have done it and allow the jury to see who the most likely responsible party is? If we know we've got one of the responsible parties in the room, why don't we just let that go to the jury and see if a jury can find it's more likely than not that one of those parties did it?
I'm going to defer a little bit to Mr. Grantham, and Judge, the reason I'm going to do this in deferring to Mr. Grantham on this subject is because I don't want to speak for his client. And I think I've spent a little bit more, but I do want to answer your question directly. As to HSS, there's absolutely no testimony that anybody with HSS ever moved those mats and put them stacked on top of the yellow ergonomic mats in the fashion that it was in when Mr. Allen fell when he was when he was walking to his gate. So as to HSS, it would be unreasonable to have HSS in the room because there's just no evidence that they were even remotely involved in moving these mats around in such a way to stack them on top of the ergonomic mats. So as to HSS, it would not be appropriate to do that. Now, I also answer the question this way, Judge. I think it's unreasonable to let the jury speculate as to who did it. They're going to have to sit there and say, well, gee, you know, in the absence of direct testimony, perhaps that would be appropriate. But in this case, the direct testimony from Mr. Grantham's, you know, witnesses of his client is that the ones that were there, we didn't do it. Now, ultimately, Judge, you do have a potential responsible party, and that's AATC, because they had overall responsibility for the concourse, and their subcontractor, RBM, while not a party, they're responsible for that subcontractor. So they're there, they're in the case, and they've got a separate motion for summary judgment. But
It seems to me, though, that there's some evidence that HSS staff controlled the mats. They decided where mats went and that they on occasion moved mats around. Isn't that part of the record?
It's not a completely accurate statement of the record, Judge. They in terms of control of the mats, to a certain extent, that's an irrelevant inquiry. Because let's say I've got a baseball bat and it's my bat, it's in my garage, and I loan it to you and you go hurt somebody with that bat. You create the hazard, you do the damage, but it's my bat and I had control over it. But then on the day that the injury occurred, you were actually in control of the mat. So the question is not overall who has control of the mats. The question is who put the mats in the position that Mr. Allen confronted on the morning he tripped and fell.
Right, but if you have the one autographed bat by Babe Ruth, and that's the bat that destroys the window, and you say you have the testimony, you have sworn testimony, I was never there, I loaned my bat to so-and-so, and then another person who was seen with the bat says, well, I didn't do it, I didn't have the bat on that day, or I didn't use the bat that day. Aren't we in exactly the same position? We don't know, but there is an inference that can be made that, you know, since you own the bat and control the bat on some occasion, that you might have controlled it on that occasion.
Judge, that destroys the standard of law. I mean, that destroys what a jury is entitled to hear as evidence. The fact that I own the bat, the question is, who created the hazard? That's the critical question here. And there's absolutely no evidence that anybody from HSS, not only on this morning, but on any other morning, stacked the mats. The fact that we may have moved the mats from location to location on occasion is an irrelevant inquiry and misleads the jury as to the inquiry they need to be following in this case. What the jury needs to understand is hear evidence of who put the mats stacked on top of the yellow ergonomic mats on the morning that Mr. Allen fell. And there is no evidence, nowhere in the record, that anybody from HSS ever stacked the mats, much less on the morning of this occasion. So for those reasons, I don't think that HSS is a reasonable party in the room under the analysis that you were talking about. One thing that we did not raise in our brief, because it was raised in Mr. Stoddard's subsequent brief, or his reply brief, was that the joint venture, HSS ATL LLC, because it's a joint venture, is responsible for all of the the liabilities that may befall the two members of the corporation. And I took with great interest the discussion that occurred in the case that you just heard, where you looked at the operative elements of the agreement. And one of the things that's critical to a joint venture is one of mutual control over the idea of a joint venture. What you really have here is an LLC that was created with two entities as its members. And within the contract, Article 7.4 of the contract that is the LLC, there is a limit of liability where no member manager is liable for any debts, obligations, or liability of the company or each other by reason of being a member and performing its work. So just the mere fact that they are, talked about as being a joint venture does not mean that HSS ATL or HSS is responsible for All-in-One Security, or that All-in-One Security would be responsible for HSS or HSS ATL LLC. All of these entities rise and fall based upon their own actions and their own contribution to whatever occurred in this scenario. And so under this scenario, they each need to be looked at separately, and what did they or did they not do to cause or contribute to the fall. And at this point, Judge, since we're going forward with the idea of the two motions being heard simultaneously, I'm going to defer and turn the floor over to Mr. Grantham to let him address the issues with respect to All-in-One Security, and reserve the right to respond to Mr. Stoddard.
All right. Grantham.
Judge, good morning. Brian Grantham on behalf of All-in-One Security.
Go ahead.
Thank you, Judge. Judge, our motion should be granted in two ways, and Mr. McDaniel highlighted those. First, we have an absence of evidence that my clients did anything negligently here. The issue here is Mr. Allen alleges he tripped over 3 stacked anti-fatigue mats. We have taken more than 24 depositions, and not a single person has been able to say that on January 9th, 2019, that All-in-One created this hazard. But it's actually more than that, Judge. We have positive evidence that All-in-One did not create the hazard. There were 4 All-in-One guards who worked contemporaneous to this incident, which occurred at about 7 a.m. on the morning of January 9th. So there was a guard named Erica Peak who was working at the time of the incident. Her shift began at 6 a.m. She was asked if she had ever even seen the mats stacked on top of each other the way Mr. Allen alleged, and she, without equivocation, said no. She was asked if she'd ever seen a security guard do it. She said no. She was also working with a gentleman named Alton Armwood, and Mr. Armwood was asked, okay, you never saw All-in-One Security stack the mats that day. And he said no. On the shift prior, on the overnight shift, there were 2 guards named Omar Smith and Elliot Jackson who worked. And they were also shown the picture of the 3 stacked mats. Mr. Smith was asked, question, have you ever seen the mats in that orientation? Answer, nope. Have you even seen any of the security guards standing on top of multiple mats at the same time? Answer, no, it always just be that one mat. That's on page 37, 38 of his deposition. There was a gentleman named Elliot Jackson who worked the overnight shift. He was asked, have you ever seen an All-in-One guard stack the mats and put them on the concourse? Answer, no. That was on page 43 of his deposition. And so, Your Honor, often in these slip and fall or trip and fall cases, a defendant is stuck having to prove a negative. And this is actually one of the cases where we're able to do so. Now, Your Honor raised some questions with Mr. McDaniel that I want to answer. First, you talked about the Babe Ruth bat hypothetical. And essentially what you're
asking.
asking.
Bad hypothetical, but best I can come up with at the top of my head since.
Yes, sir. I actually think it's a very good hypothetical. Let me tell you why. Because what Your Honor is actually getting at is res ipsa loquitur. And the reason this case is not res ipsa is for res ipsa to apply, the defendant had to have exclusive control over the hazard. And here, it's very clear from the testimony, All-in-One did not have exclusive control. As you mentioned, HSS had moved the mats previously. ABM, the janitorial company, moves them every night in the early morning hours. So your bat hypothetical is actually very illustrative of why All-in-One should get summary judgment here, because it did not have exclusive control over the hazard here. And so because of that, the positive denials by the All-in-One security guards must carry the day. So
Let me ask
opposing
let me ask this question from a practical matter.
yes, sir.
If you've got three possible alleged tortfeasors, the plaintiff never saw who was the actual tortfeasor, and all three affirmatively testify it wasn't me, is the plaintiff just out of luck because the only evidence is that they said they didn't do it, and the plaintiff doesn't have any firsthand or secondhand ability to rebut those statements?
Your Honor, your question depends upon the legal duty to which plaintiff is owed by those three potential parties. So in this situation, HSS and All-in-One have a legal duty to plaintiff to simply not create a hazard. Whereas if you own or occupy that space, so you might be City of Atlanta, Your Honor will get to rule as to whether AATC owns or occupies that space. That's why Georgia law draws a distinction between independent contractors and owners and occupiers of a space. If you own or occupy a space, you have a duty to exercise ordinary care to keep a plaintiff safe from hazards you knew about or even should have known about but didn't know about. But All-in-One doesn't have that duty. HSS doesn't have that duty. They've got a duty to not create a hazard. It is plaintiff's responsibility to present evidence that they created the specific hazard, or that only they could have created the specific hazard. And so to that end, Your Honor, obviously plaintiff argues that there is testimony in the record that on some dates in the past, some unidentified All-in-One security guards have stacked the mats on the concourse. But we know that it wasn't the four guards who worked on the date of this incident. And so I want to cite for Your Honor a case, Copeland versus Houston County Hospital Authority, 215 Georgia Appeals 207. And essentially the holding of that case is it's a well-established principle that in ruling on a motion for summary judgment, a finding of fact that may be inferred from but is not demanded by circumstantial evidence has no probative value against positive and uncontradicted evidence that no such fact exists. And so plaintiff wants to present circumstantial evidence that All-in-One created this hazard. But what we have is positive, uncontradicted evidence that All-in-One did not create the hazard. And so because of that, plaintiff cannot rest their case on circumstantial evidence to defeat summary judgment when we can positively show we didn't create the hazard. The second way plaintiff's argument fails is essentially the argument they're making is that they want the court to accept that because an All-in-One guard, not necessarily on January 9th, but maybe at some point, and not necessarily one of the four guards who were working that day, but maybe some other guard, negligently stacked the mats before, that All-in-One has to be liable this time. So long-standing Georgia law holds that in a suit for negligence, evidence of similar acts or omissions on other and different occasions are not admissible. And for that proposition, I would cite Holloman versus Hobson, which is actually from 1932, 45 Georgia Appeals 762. So plaintiff's argument is akin to in a car accident, saying, well, the gentleman driving that blue car, I've seen him speed on other days. Therefore, he had to have sped on this day. Therefore, there's an issue of fact as to whether he's negligent. Georgia law doesn't allow for that analysis. So Here, plaintiff's argument is circumstantial. It requires the court to accept evidence of alleged prior unconnected negligent acts by All-in-One, where we have positive, uncontradicted testimony that the 4 guards working on the date of this incident did not create the hazard. Because that testimony is uncontradicted, it has to defeat the circumstantial evidence, which plaintiff seeks to admit here, Your Honor. Thank you.
All right. So I think that is HSS, and that is All-in-One Security Services. So I think we have left AATC.
Good morning, Your Honor. Austin Hyper for AATC. It's my understanding that today is just the motions for the 2 security companies. We haven't yet received hearing notice for AATC's pending summary judgment motion or their motion for protective order.
All right. You agree that that's the procedural posture, Mr. Stoddard?
I do.
All right. All right, so Mr. Stoddard, you can fire when ready.
Okay. No one has direct evidence, and I'm going to come back to that, but no one has direct evidence of who stacked those mats. Everyone's evidence is circumstantial. And the law that Mr. Grantham told you has a number of exceptions which apply. But I'm going to come back to that, and I want to start with responding to HSS. The first thing I want to respond to is something that we briefed, that no one else briefed, but that Mr. McDaniel sort of touched on. And that is our position, which is the law, is that all of these security companies are treated as one entity today. They may have separate insurance policies, they may have separate lawyers, but the law says they are each other's agent. And I've got that law right here. I'm going to put it up on the screen for you. And I've got evidence
I
of
have
that.
to allow you to share the screen, so give me just 1 second here.
Okay.
All right.
Thank you,
Right
Judge.
now.
Let's see, right here. Okay. So joint venturers are jointly liable. All joint venturers are liable for the negligence of the other joint venture, and agency principles apply. So each is an agent of the other. Each entity is bound by the action of the other. Each agent is charged with the knowledge of the other. And that comes from a Georgia Supreme Court case called Kissin v. Humana, which we cited. The theory of joint venture arises when 2 or more parties combine their property or labor or both for a joint undertaking for profit with rights of mutual control, if it's not a partnership, so as to render all joint venturers liable for the negligence of the other. And it also says in that case, the general principle of agency law applies where the defendants are joint venturers. So what that means is what HSS does, All-in-One is responsible for. What All-in-One does, HSS is responsible for, if they're joint venturers.
Okay, I think I get the implication that their argument is that, well, we've contracted out of that.
They have not. That's the first I've heard that today. And so I haven't fly-spec'd the contract, but I'm about to show you evidence here, sir. This is the 30B6 deposition of HSS, where they admitted that they're a joint venture, and they've admitted the underlying facts that support that. All-in-One supervisor can certainly tell an All-in-One guard what to do, yes, but an HSS supervisor can also direct an All-in-One guard, correct. And the nature of the relationship, the reason they can do that is because it's a joint venture out there. That's correct. And the same thing is said in the bid to the city. There's a name of the joint venture, which is this party, and then the firms participating, the joint venturers, are the other 2 defendants, HSS and All-in-One LLC. And so that is the agreement that they reach. Now, why are they a joint venture? Because the city of Atlanta has said that we're awarding contracts to minority-owned businesses. I'm not sure if it's related to race or gender, but HSS is sort of a national outfit that runs security at every airport in the country. And All-in-One is a local Atlanta outfit that has minority ownership. And so HSS wanted to come in and get some of that money from the city of Atlanta to secure the airport. They wanted the profits. So in order to do that, they had to partner with a minority-owned business that's local, which All-in-One was happy to do, to come in and do it together. Well, you share the profits, you share the control, you also share the liabilities. You can't contract out of the bad just to take the good. That's what our law says, and that's what the facts of the case are. So that's the first issue I want to talk about. No one briefed that but us. No one disputed it, except today you heard Mr. McDaniel mention it for the first time and talk about some section in a 50-page contract that I admit I haven't fly-specced. But we have evidence that there is a joint venture. They've both admitted it in deposition testimony. They've admitted it in interrogatory responses. And the law says that when one applies, each is responsible for the other. These three entities are the same. So that's the first point I wanted to make. The second point I wanted to make is about the duties. They're a little bit broader than what I think the defendants have said. I generally agree. There's not a 5131 duty here. We are not arguing that the security companies are occupiers of the airport. But here are their duties. They have a duty to use reasonable care in performing their contract. Don't contribute to a hazard. Don't make things less safe. Don't create a hazard. They also have a duty to use reasonable care not to increase the risk of harm to anyone. The first part of that, the duty to use reasonable care to perform a contract, comes from our common law. Prescott is one case that says it, and all three cases I'm about to show you are cleaning company cases where a janitorial company ended up getting, at least at the summary judgment stage, said the jury can say you're responsible. So a cleaning service has no duty to inspect, that's true, but they do have a duty and they are liable for negligently performing their contract work. That's the Prescott case. They say it again in RS Farms. We recognize that an independent contractor is liable for negligently performing the contract work. And they say it again in Kelly v. Piggly Wiggly, which is my favorite of the cases we cite for two reasons. One, it is like an in-bank opinion. So it's a more substantial precedent, 7-judge opinion. And also because it gives you a little more of a flavor. It's not just one sentence. But they say the duty imposed on an owner of the land is 5131, and it's not applicable to these independent contractors. We agree. But they have a duty to use ordinary care in floor cleaning and cleanup, just like our folks here have a duty to use ordinary care in their security services, because a contractor may be liable for negligence performance of the contract work. And they kind of agreed to this today. They've said it in their briefing. They have retained a duty to use ordinary care. They both said it. I think this is too, this from all in one. I think this is too narrow. Their duty is more than just not to create a hazard, but I agree with that. That is part of the duty. There is another duty though, and it's similar, basically says the same thing, but another basis of it. It comes from the restatement, and our Georgia Supreme Court has adopted it. Liability to third persons for negligent performance of an undertaking. So here the security companies for money provided service to the city, and clearly everyone recognizes it was for the protection of the customers. They've said that in their depositions. And so they're liable for failing to exercise reasonable care if their failure to do so increases the risk of harm. So those are the duties that we're after, and they're all in it together. That's the first two things I want to talk about. The next thing I want to talk about is the evidence. What's that evidence? Well, here it is. And I disagree with some of the things that Mr. Grantham said. There were a lot of people deposed, but I disagree with some of the points that he made. I don't think that's a clear version of the evidence. Here's what we're about to show you. This is our position on the evidence. Just standing a guard around the hidden corner was negligent. And I'm gonna show you why, because they knew it was a problem and they knew other people had been bumping into the guard. Just placing one mat around that corner, that's negligent for the same reason. And again, I'll show you why, because the security guards will tell you in deposition testimony, they knew it was a problem. They went and explained it to their managers and they were told to be quiet about it and do something else. And the third thing is the one we've really been talking about. Placing a stacked group of mats in that location is a hazard. So here's sort of what we're talking about. I assume Your Honor has been to our airport. That would be unusual if you had not. So it's on the C concourse, and to kind of orient you here, this sort of horizontal way, this is coming up the escalators from the plane train. So people are coming up these escalators from the plane train. If you're walking sort of as I'm moving this mouse, you're about to get to the C concourse, and going this way, you've got C1 to 23, and up here you've got C24 to 42. So Mr. Allen is coming up the escalator, and he's going right around this corner here and down this concourse. And that red dot, that's where these mats were, right around this corner. And the other thing to note here is there's a little alcove back here, and I'm going to talk about that and the point. Here's a picture of it. This is being shot from the concourse. So the photographer is standing at gate like C21, shooting towards gate C42. And to his right, if he turned that corner, would be that escalator. And this is where they wanted that security guard to stand. This picture was taken right after the event, I believe. That's just the opposite. You're looking at C4, the photographer's more like C30, shooting down towards C1. He's standing, he's got the escalators to his left and right. This is Mr. Armwood, the guard that was supposed to be there, trying to look like he didn't do anything wrong. And we'll talk about that too, and him. This is the deposition testimony. Mr. Elliott, a security guard, is saying that it's his job to stand at center point on that map. When they're not doing inspections, which is sometimes they go down an escalator to let in like the guy that works at Wendy's. But when they're not doing that, because the Wendy's guy doesn't come through regular security, when they're not doing that, they're supposed to be standing on that map. That's what he's saying his job is, to stand on that map. This is HSS security guard supervisor, Mr. Harden, telling us mission complete, map placement complete, about 6 months before our incident, telling all the other security guards. And he's saying in the same text, he's putting mats out on the C concourse. You'll notice what these mats look like, the same ones that Mr. Allen tripped over. And this is a picture of the C concourse as testified in deposition testimony of the 3 mats he placed out. Mission complete. Those are the mats I'm putting out there. 6 months before.
Mr. Stardy, could you please slow down a little bit?
You're not the first person that's told me that. I'll do my best.
Thank you. Thank you.
This is sworn under oath testimony of one of our security contractors, saying the other one owned, placed, and had control over the mats. Now, in your Babe Ruth example, when the Babe Ruth owner of the bat gave it to someone else, the Babe Ruth owner no longer had control over that mat. He gave it to someone else. But here, you've got an admission against interest. This alone gets you over summary judgment. You've got the security company saying they placed and controlled the mats. That is a sliver of evidence, which is what you said to the last group, that a sliver of evidence authorizes the jury to come out another way. That's enough at summary judgment. But we've got more. This is Elliot Jackson, that security guard. I've seen another guard move them. It sounds like if there were mats in this spot where you're supposed to stand, you would move them to the alcove. Yes, we would. I think you observed other security guards moving the mats around too. Is that right? Yes. Yes, I did. This is again, Mr. Jackson, the security guard. And this is Mr. Jackson. So you personally move the mats out of the back and onto the concourse. Yeah. Sometimes, we'll just move it back out onto the concourse. Just lay it back out on the concourse. That's a security guard talking. This is another security guard. The yellow footprint mat, your company would pick it up and move it so they could clean it? Yes. And then they'd put it back? Yes. Correct? This is a janitorial contractor. It's actually ABM, not RBM, but a janitorial contractor hired by the terminal company to clean the floors at night. And what does he have to say? The security guards, they stand on the mats. I know they double stack them. I know the security guards double stack the mats, so they'll have more cushion under their feet. This is another cleaning company person. We only remove the mats to clean the area. We don't touch them again. We take them off the concourse. The ABM employees would not put them back out. So the cleaning company would not put them back out. That's correct. This is the terminal company. All-in-One Security is the contractor responsible for the mats. Pre-suit. This is the city of Atlanta, a year after this incident. They've just now had another incident where someone tripped on mats. And so the city is telling the security companies, these are the bosses of the security companies, y'all need to remove all these mats. It's a problem. It's a slip and fall problem. And what is the response from the head guy at All-in-One? All mats were removed by Sierra One, which is an HSS designation. That's an HSS supervisor last year. So the people that are in control of them, that are moving them around, are the security companies. This is Elliot Jackson again. How frequent did you see mats stacked like this? Every day. Every day they were stacked. This is Miss Robbins, a janitorial company person. Have you ever seen the security officer standing on stacked mats? Yes. Saw it when I walked past on a regular basis. Mr. Bruton again, the janitorial company. Every time you move the mats before you start cleaning, the mats are in that area and they're usually stacked on top of each other. Yes, they are. And have you ever seen the security officer stand on the tack? Yes, they double stack them so they have more cushion under their feet. And this is the other part about it. It's not just stacked mats. This is a security guard pre-incident test, or deposed post-incident, but talking about pre-incident. You knew the mats would be a problem because I've seen people trip on them. I've almost tripped on them. When you stand right there, people will walk into you because of the corner. They come around too fast. So a lot of people wouldn't stand right there. The place where we stood was not a good place to stand because we could get bumped into. The problem isn't just stacked mats. The problem is the security companies telling someone, this is where your post is, around a hidden corner on a busy airport concourse, when they knew that it would often happen that people would get bumped into. And so because of that, Mr. Jackson, the security guard, would move them. And he did it because he saw a couple people trip over the mats coming around the corner too fast. In fact, he even complained about it to his boss, Miss Henderson. We need to move these mats because people can trip over them. And she didn't do anything about it. She said, she downplayed it. She said it wasn't my focus to focus on the alarms. And the reason that he had moved them is he understood them to be a trip hazard. And so that's the testimony. So to sort of review it, security chose the spot to stand in and the spot where the mats were placed, and they knew that that was a bad spot. Security would move the mats as part of their work. Other guards had moved them. I've moved them. Janitors would take them off but would not put them back. Security would put the yellow mats back after moving. Security double stacks them so they'll have more cushion under their feet. All in one, is there a security contractor responsible? All the mats were removed by the security folks, that's an HSS person, last year. And they chose not to fix a problem they knew about. They knew standing there was bad. They knew people come around the corner fast. They knew people would get tripped and bumped into if you stood there. They knew the mats would be a problem. They'd seen other people trip. They'd sometimes move the mats. And this guy Jackson had even complained to his supervisor, and they knew they were trip hazards. So that's the evidence. It is not a situation where you have direct versus circumstantial evidence. It is a situation where everyone's evidence is circumstantial. Now, that's partly because when the terminal company showed up right after the incident and they started taking pictures and interviewing witnesses, they chose not to go get the video feed that would have showed exactly who stacked the mats. And we'll be talking about that, I think, in a few weeks. But that's one of the reasons we don't have direct evidence. But direct evidence would be a security company person saying, you know, that morning I saw so-and-so, I don't know, Will Smith was doing a movie in Atlanta, and I saw him come around the corner and stack those mats that morning. That is direct evidence of how they got that way. No one has that here. What we have is two guards who were on shift for 45 minutes to an hour before the fall. There's, three guards, two all-in-one and one HSS are responsible for C concourse. Those guards knew about this, and they each claimed they didn't do it. Those guards have been impeached already. And when you have impeached direct evidence, that no longer carries the day. They're impeached because they said they never stand on stacked mats, they never move mats, they never stack mats, they've never seen mats stacked. Where on the other hand, you've got other testimony of they're stacked every day, security guards are always standing on stacked mats. So the direct versus circumstantial thing, even if it was direct, which it isn't, doesn't apply anymore when someone's been impeached. But we have a lot of circumstantial evidence that shows these security companies are the ones that are responsible. No one has direct. Those three guards had been there for an hour, and all they said is, I didn't do it myself, and I was there for 45 minutes. The shift before, you've got three more guards. The two all-in-one guards were interviewed under oath 2.5 years after the incident, and that's the first they heard of it. Their only testimony was, as a policy, I don't do that. I didn't do it. I don't remember doing that. I have no memory of that day. I had no concept of what happened, but I don't generally do that. The HSS supervisor from the shift before has not been deposed. The janitorial worker that was supposed to move the mats that night during that previous shift, he doesn't remember that night either. He just tells you what his general policy is. Who knows how long those mats were there? The jury could find they've been there for 3 or 4 shifts. There's no direct evidence that every single security guard that was working, we saw the mats were not stacked at this hour. From every hour since then, the only security guards that were there were numbers 1, 2, and 3. They all remember that day. They were there, they were interviewed under oath that day. They saw the fall. They didn't do it. That's direct. That's not even direct. That's circumstantial, but it's stronger circumstantial. Direct is I saw this guy stack them, and they don't have that. Now, Your Honor did talk about res ipsa, and I want to go back to that because I think it is important, and I do think it applies here. The testimony really is there are two possibilities. The security company stacked the mats, or ABM stacked the mats. ABM is an independent contractor working under the terminal company, and the terminal company is responsible for what ABM does. 5131 is a non-delegable duty. There's case law we cited in our motion against the terminal company, which is not pending today, that shows that whatever ABM does as an independent contractor trying to fulfill the role of making the terminal safe for the occupier, the terminal company is responsible for that. Res ipsa flips the summary judgment standard and the standard for the jury and makes it the defendant's burden to prove that the other one did not do it. And that does apply here. One of the last things I want to talk about was other incidents. You heard Mr. Grantham cite a case from 1932 that said definitively that other incident evidence is not admissible. I don't think that was the rule in 1932. I think that that was the rule with exceptions in 1932. You certainly will not find a premises case in the last 30 or 40 years that says that. As Your Honor knows from other trials, in premises cases like negligent security cases, you're constantly relying on prior crime. Those OSIs come in. In products cases, OSI, other similar incidents come in. You do have to show similarity, but other evidence of what happened on other occasions can be admissible if it's similar. And that's something for the motion in limine stage or something for the jury to determine. But we can bring forth testimony that it's the policy and practice, and on every day, the security guards are stacking the mats. Give me one moment, Your Honor. I want to read through my notes to make sure I haven't missed anything. I think I'll leave it at that, Your Honor. Thank you.
All right, I'll turn it back over to first Mr. McDaniel and then Mr. Grantham to give me the final word.
Yes, thank you, Your Honor. I've made a couple of notes that I wanted to address specifically, and I think that, Mr. Stoddard's, evidence regarding HSS is not sufficient to keep the court from denying summary judgment to HSS. And specifically, if you go back to the photograph, and Mr. Stoddard was correct that it was approximately 6 months before the incident that Mr. Harden was moving the mats around in terms of being under the directive of AATC to put the mats out. That's to whom he was responding when he said mission accomplished. And what I wanted the court to recognize is when you look at the second photograph and you look at the location of the placement of those mats, you had what I call the ergonomic mats placed against the wall. That's the one with the 2 yellow footprints, and the other cushion mats were off to the side in the alcove that we talked about. That's where HSS placed the mats. That's where they were supposed to be. There's no evidence that anybody related to HSS moved those mats other than on those occasions to put them in that area. And the evidence with respects to stacking the mats as to HSS is simply that there is none. And if you go back to what Mr. Stoddard said from a legal perspective, not to perform our contract negligently, for HSS's delivery of that service to the contract, they didn't do it negligently. There is no indication that, again, anybody with HSS was involved in placing the mats in a hazardous condition at the time that Mr. Allen fell. The fact that others may have bumped into the area bumped into a guard is not really relevant to the situation in this case, because that's not what happened. That's not what happened with Mr. Allen. Mr. Allen came around the corner, and if you notice that the guard said, we noticed that people, when they would come around the corner fast, I think was the word that was utilized in the deposition, they would trip over the mat. And in this particular case, what happened was you had 3 mats stacked on top of one another, and that's what Mr. Allen contends caused him to fall. That was not caused by anything that HSS did or did not do. There's no evidence anywhere in the record that anybody with HSS stacked the mats on any occasion. With respects to the joint venture argument, and one of the reasons that it was not briefed, Your Honor, is because that was not the basis by which we moved for summary judgment. Your Honor has a policy, and perhaps I should have asked, but Mr. Grantham did ask to respond to Mr. Stoddard's brief, but you have a policy of not filing reply briefs, so I didn't file a reply brief. And I apologize if I should have asked to respond in a brief to an argument that was raised by Mr. Stoddard, but I didn't. And the reason I didn't raise it in the very beginning of the motion is because I typically don't take the posture of setting up arguments to then knock them down. We were moving on summary judgment based on the fact that HSS and HSS All-in-One ATL LLC did not cause the hazard that led to his fall. That's the reason why there was no mention in the brief. And if the court would want me to brief it further, I'll be happy to do so, but that's why there was no reply brief that was submitted. But one of the things in the cases that talk about a joint venture is that let me find the case citation. It's the Williams versus Chick-fil-A case, Your Honor. And it's a 274 Georgia App 169 at 170. And the issue is in terms of overall establishing the joint venture and creating, this agency relationship, is the right to exercise mutual control is a critical part of the joint venture. And in this particular case, if you look at the contract, and yes, the contract is part of the record, and the contract sets out what the obligations are with respects to these various entities. And I will now defer, Your Honor. I appreciate the time. We still believe that under the facts of this case, the plaintiff has not put into the record evidence sufficient to create an issue of fact regarding the role of HSS in the fact that the mats were stacked and allegedly created a hazard for Mr. Allen. Thank you.
Okay, Mr. Grantham.
Yeah, Your Honor, thank you. Again, I think what this comes down to is the general evidence that at some point, some guards on some days supposedly stack these mats to create the hazard. And what Your Honor has to remember is this is shift work. People work different shifts. They work different locations, things like that. But what we do have is positive evidence by the 4 all-in-one guards who could have created this hazard, and they all deny having ever stacked floor mats. So they could not have done it on the day of this incident. And because of that, there's simply no evidence by which all-in-one can be found liable. There's no evidence all-in-one was negligent. Thank you, Judge.
All right. Mr. McDaniel, Mr. Grantham, I appreciate your arguments. I appreciate your arguments regarding the lack of direct evidence and the evidence that you have presented from your employees. And I think those are excellent arguments for trial. But I think ultimately that they are trial arguments. There is clearly evidence in the record as to past practices and ongoing practices and who has control ultimate ownership and control over the mats and where the mats are normally placed. And there is enough evidence in the record that these folks are going to be subject to cross-examination on their denials. And it's going to be up to the jury to decide whether their denials of having anything to do with those mats ever or on the date in question, the jury is going to be entitled to draw their own conclusions about who was responsible. You know, you've got contrary testimony in the record from the janitorial services, and I know they have their own self-interest in that, in saying, oh no, I saw them stack it and they did it. And that may not be entitled to ultimately carry the day by the jury, but it is certainly evidence. It is certainly evidence that tends to contradict the explanations and the testimony of the all-in-one security employees. So there is a question of fact here. There's a question of fact here on that issue as to who ultimately created this hazard. And frankly, I think, you know, there's some evidence here as to causation, whether it was the stacking of the mats that caused it on that day, or whether it was the location of the mats as decided initially by all-in-one security. Maybe it's not the strongest, it's not the stronger of the arguments. Certainly the stronger argument is that somebody stacked them and created a tripping hazard, rather than they would automatically trip or be a hazard just by being in that position, even with one mat. But even that appears to me to be a triable issue in a theory that makes it past the issue of summary judgment. You know, I think on the joint venture issue, we've got what the default law is, and we've got some testimony in the record on what the practice is for the joint venturers as to who would direct the employees. So I think there's enough evidence, maybe slight, but enough evidence to bring in the joint venture as well as the participants in the joint venture on this issue for trial. So the motion for summary judgment is denied by both HSS All-in-One and HSS Inc. and on All-in-One Securities motion for summary judgment. Mr. Stoddard, I'm going to ask you if you would to prepare a proposed order. Please run it by Mr. McDaniel, Mr. Grantham. If you all don't object to the form, I know you object to the substance, but if you don't object to the form, then I'm going to go ahead and get it entered.
We would just ask Matt, if you would, when you prepare it on the left-hand side, just put a position where it says consented to as to form for both myself and Mr. Grantham. That'll make it easier for us to approve it. You probably would have done that anyway. I just didn't want to assume that.
No problem, Charlie. I'm happy to do that. Ms. Winfrey, I'd like a copy of today's hearing. Thank you, Judge Richardson.
Thank you, Mr. Stoddard. No problem.
All right, so I know this may be premature and, you know, there may be other things that happen in the meantime, but what do y'all think about a non-jury trial on these issues? I know y'all probably haven't had a chance to discuss it with your clients, and, you know, there may be sort of a reflexive, no, we want a jury, but I would just bring that up and ask you to consider and discuss with your clients the possibility of a non-jury trial, because we can resolve it a lot faster that way. Jurors are at a premium these days.
Judge, when you say non-jury trial, are you speaking for the cases in its entirety, including damages?
Yes.
Okay. Again, I didn't want to assume, but that's what I thought you meant.
I'll talk to my client Our position for many cases has been that we would agree to that while there were not jury trials going, and everyone told us no. I don't remember if I don't think these people, we haven't had that discussion in this case.
We've not.
I don't, and so I will talk to my client. He may also be agreeable to a 6-person jury trial if he's not, but we will discuss both.
A six-person trial would be manageable at this point at a far sooner than a 12-person. And obviously a bench trial, I mean, you could probably have that in 3 weeks if you wanted one.
We might need a little more than 3 weeks to get the case ready for trial of this complicated nature, but I understand what you're saying, Judge.
Yeah, you could pick a date and say, Judge, can you do it this day? Well, I can't do it on Wednesday, but I could do a bench trial on Friday. All right.
Thank you, Your Honor.
Thank you, counsel. And I appreciate your patience and bearing with us and having to get together twice, but we got it done ultimately.
We did. Thank you, Judge.
Thank you, Judge.